Hi there. Welcome and thank you for joining us today. The USC Family Caregiver Support Center is pleased to provide this educational video for families and relatives who want to learn more about legal and financial planning as they take care of one or more loved ones. Today's topic will be an overview of legal documents such as wills, trusts, and powers of attorney. I'm Jenny Peterson, and I will be your host for today's program. I'm here today representing the USC Family Caregiver Support Center, which serves and supports family caregivers as they navigate through their caregiving journey. The center provides services such as information and referral, support groups, evidence-based trainings, community education, and much, much more to family caregivers seeking help. We like to think of ourselves as a valuable lifeline and an important resource for family caregivers. Our center is also home to the Los Angeles Caregiver Resource Center, otherwise known as LACRC, which is part of the California statewide system of 11 caregiver resource centers. Now, if you happened upon this video by chance and you don't know about our center yet, please visit our website at www.fcsc.usc.edu for more information. Better yet, you can even sign up for our program right on our website through the yellow CareNav tab on the right-hand side of the page. We know that family caregivers need support, and our center is here for you. Now, today's presentation will focus on an overview of some crucial legal documents that family caregivers should have. Many of us often do not know where to start when we begin thinking about legal documents that are needed for our particular caregiving situation. So this is the perfect opportunity to learn about some of the basic legal documents that caregivers need to consider putting into place. We will discuss wills, living trusts, and powers of attorney. Why are these legal documents necessary and important for family caregivers to know about? With us today is Sarah Polinsky from the law offices of Sarah Polinsky in Sherman Oaks. Ms. Polinsky is an elder law attorney who specializes in these topics that we are here to discuss today. Sarah, take it away.
Hi, I'm Sarah Polinsky, and I'm very happy to be here today to talk about Legal Docs 101, the basics of estate planning, getting into terminology and understanding of living trusts, wills, powers of attorney, probate, and more. So hopefully this will be good information that will help everybody understand better and make good decisions moving forward. So let's get started. The first thing that I want to talk about is the very basic documents involved in estate planning. We have wills, we have living trusts, we have financial powers of attorney, and we have healthcare directives or medical powers of attorney. These are basic legal documents that are necessary and important to get your wishes down in writing in a legally enforceable way, make it known who you want to be in charge, who you want to receive things from you, what kinds of decisions these people can make for you, and when. And in just a second, we're going to look at all these documents and discuss them side by side. But I just want to point out that a lot of times people confuse the terminology, and they'll say a will when they mean a living trust, or they'll say a power of attorney when they mean a will. And we'll see in just a second that each document really has its own purpose and terminology that flows with it. So going on to the next slide. So let's go ahead and compare the basic documents, which are living trusts and wills and powers of attorney. The first and I think most important difference between them is to know when each document takes effect. They all are triggered by different events. For example, a living trust can go into effect during your lifetime if you become incapacitated, as well as at the time of death, whereas a will only takes effect at death. So sometimes people mistakenly think that an executor of a will can step in and act for them if they get sick or if they're in the hospital, but they can't, because a will doesn't take effect until somebody passes away. And then powers of attorney take effect when someone is incapacitated. So you're alive, but you're unable to make decisions for yourself or handle your own affairs. So then a power of attorney goes into effect, if you have one, to allow somebody that you've designated to act for you. And this is another big misconception. People think that a power of attorney has effect after somebody passes away, and it doesn't. It's valid during your incapacity only. The other difference between a living trust and a will is that one of them avoids probate, whereas the other one does not. So living trusts, if they are set up and funded properly, will avoid probate. A will not. If a person has a will and they have certain assets that are subject to probate, which we'll talk about in just a moment, then the will have to be probated. Probate doesn't mean that the state or the government comes in and takes everything you have. Probate is simply a court-supervised process overseeing the transfer of assets or the transfer of title from somebody who's died into the name of somebody who's living. And so if a person only has a will, their assets may have to go through probate before they can be inherited, whereas with a living trust, probate can be avoided with proper planning. In the power of attorney category, probate doesn't apply because the documents are only valid for use while a person is still living. At death, the powers of attorney become void. The other thing to note is not only does a living trust avoid probate, it can also avoid a conservatorship. So a conservatorship is the lifetime equivalent of a probate, meaning that it's the court-supervised process of installing someone to look after and make decisions for an incapacitated person. If someone's incapacitated and they have not made out a power of attorney or a living trust where they have designated someone to act for them, then they would have to go through a conservatorship to allow someone else to be able to step in and take care of their affairs. Well, with a living trust, the person in charge, the successor trustee, because they can act in the event of incapacity, oftentimes a conservatorship may be avoided. Same thing with the powers of attorney. They can avoid a conservatorship because the whole point is to nominate someone to be able to step in and act for you at a time when you're no longer competent. Just because you have these documents, it's not an absolute thing that a conservatorship will be avoided, because sometimes even if the documents are there, maybe the individuals that are named are no longer able to act, or there's a dispute of some kind that will require court action. But typically, in many situations, a power of attorney and living trust can help to avoid probate if somebody is alive and incapacitated. A will, however, does not avoid conservatorship, because remember, it doesn't take effect until somebody dies. So if all that someone has is a will in terms of their legal documents and they become incapacitated, then the only way to allow someone to be able to step in and help take care of things for them is to go through a conservatorship. And then the other difference I want to point out is what we call the person that's designated to be in charge of each document. So you, as the creator of your own documents, you are going to decide who you're going to appoint to be in charge. But once they're named, they have a title, and depending on which document they're using, their titles differ. So the person in charge of a living trust is called a trustee or a successor trustee. Under a will, that person is called an executor. And under powers of attorney, the person in charge is called an agent or an attorney in fact. And very often, it's the same person that's named in all the documents, but depending on which document is being used to take care of your affairs, they will be referred to as either a trustee, an executor, or an agent under a power of attorney. Okay, next. So let's talk a little bit more about what probate is. I explained a few minutes ago that it's a court-supervised process wherein the court is overseeing the transfer of ownership from somebody who has died to somebody who's still alive. Not all assets are subject to probate. In California, probate can affect property, real property that's worth about $55,000 or more, and or liquid assets that have a combined total, so everything added up together, of about $166,000 or more. There are a couple of exceptions to probate, and we'll cover that in just a moment, but this is the general rule. So if somebody has a house and has at least $55,000 of equity, or the property is worth at least that, if it's not in a trust, or if it doesn't fall into one of the exceptions, then it may be subject to probate. And so what I like to point out to clients and when I do seminars is that probate and living trusts and estate planning, it's really not about wealth. It's about title. It's about ownership at the time of death. If you own property and your name is on it and you pass away, if you have not planned to transfer title to your property when you're no longer here, your family members can end up in probate because that will be the only alternative to go to court and have title transferred, unless, of course, as I said, it falls into one of the exceptions. So probate affects real property worth about $55,000 or more, and or liquid assets that are worth about $166,000 or more, unless they fall into one of the exceptions. Okay, next. So now here are the exceptions to probate, and let's kind of look at each one and talk about them. The first, and I think most important one, is joint tenancy. Property held in joint tenancy with another person or with other people is exempt from probate because joint tenancy has something that goes with it called a right of survivorship. So if 2 people, 3 people, 4 people own property or are on title to an investment account as joint tenants, if one of them dies, then the surviving co-owners will continue to own, and they don't have to go through probate to keep their ownership interest. So a very common example of joint tenancy is a husband and wife typically own property as joint tenants. When they purchase property, they take title. John and Mary, husband and wife, as joint tenants. If Mary passes away, the husband will be able to remove her name from title by filing certain legal documents with the county recorder and attaching a death certificate. And the ownership of the property will transfer to him as the surviving joint tenant without the need to go into probate. I have a little asterisk next to joint tenancy, though, because I just want to caution everyone that even though joint tenancy does avoid probate, which makes it a very popular form of co-ownership, there are some unintended consequences that flow from joint tenancy. For example, if a husband and wife wait until the first person passes away to do a living trust because they know that under joint tenancy, if one of them dies, the survivor won't have to go through probate, issues do arise where the survivor may not be competent at that time to do a living trust, to sign legal documents. And so then there's no way to avoid probate. The heirs would have to wait until that surviving spouse passes away, and then they would have to do a probate at that time because they weren't able to do a trust during their lifetime. Another kind of a misstep with joint tenancy is sometimes people understand that it's a quick and easy way to avoid probate and not have to go through the courts or see an attorney. So often parents will add one of their many adult children to the title of their property thinking that they have a will or an instruction in place that says they want their property to be divided among all their kids after they die. But as soon as they add one of, let's say, their 3 kids to the title of the property as a joint tenant, it automatically disinherits or excludes the other heirs. So if Mary died and John, as the husband, remained on title and decided to add Susie, his daughter, and one of his 3 children as a joint tenant to the house, making it easy and simple to avoid probate at his death, the minute he added Susie to the title of the house as a joint tenant, he automatically disinherited his other 2 children. So joint tenancy tends to supersede all other forms of ownership. So you have to be careful when adding people on. And a lot of times parents don't realize that they're excluding or disinheriting heirs by doing that. Also with joint tenancy, as you add people on to title, you are no longer in full control or ownership of your property. Your joint tenants have an equal share of the property. In order to be joint tenants and have the right of survivorship, all co-owners have to have an equal share. And so if you need to sell or refinance the house, now it's no longer your decision, but everyone else who's on title with you. So like I said, it's popular because it does avoid probate. People are familiar with it. We've heard the terminology for a long time, but there are some things to consider with joint tenancy, even though it's an exception to probate. All right. Also, life insurance, retirement accounts, and annuities. These types of assets can avoid probate as long as you have beneficiaries designated on the contract or the policy. When you deposit your money into a, let's say, 401k or an IRA, or you purchase an annuity and invest your money that way, or you take out a life insurance policy, it's a contract between you and that company, and they make certain promises, one of which is to pay out to your beneficiary named on the contract or on the policy, whatever is in that account at the time of your death. So I encourage people to make sure you always have a primary and a contingent or secondary beneficiary named on these types of assets. And if you do, at the time of your death, the companies will pay out to those beneficiaries without requiring a probate, even if the value of these accounts is greater than the $166,000 amount we discussed before. So it's an exception to probate because of the beneficiary designations. And then finally, cars typically will avoid probate. The DMV has its own procedure and forms for changing title at death. That doesn't require a court order or probate. So that's also an exception. So probate on property worth $55,000 or more, liquid assets with a combined total of $166,000 or more, unless the asset falls into one of these exceptions of joint tenancy, it's a life insurance policy, a retirement account of some type, an annuity, or a car. All right, next slide. Now I want to talk in a little bit more detail about living trusts, because over time I realize that people maybe realize and think that they need to have one, but they don't always understand what it is or how it works. So a living trust is something that you create. It's your wishes and your instructions and your designations. And while you are alive, usually you are in charge of your own trust and you are the beneficiary of your own trust. And everything that's in your living trust is yours. You're the owner. Living trusts, by definition, are revocable, which means that during your lifetime, you can make whatever changes you want. You can change the terms of the trust. You can name new beneficiaries. You can change the property that the trust owns. You can sell the house you currently have and buy 2 more houses and add them to the trust. You can spend your money as you see fit, because while you're alive, you are owner, you are manager, trustee, and you are the beneficiary. Living trusts are important because if they're set up properly, they will avoid probate and protect your heirs from having to go through that time-consuming and expensive probate process. Not only are you in charge while you're alive, you will also designate who steps in as your successor trustee in case you become incapacitated or pass away. You're going to designate those individuals who will take over. And you're going to designate, obviously, your beneficiaries. Who are you going to leave everything to? Whether it's percentages or specific items, those will be your wishes described in that document. So, and you will be able to change those wishes during your lifetime so long as you're competent to do so. And I get a lot of times is, can the person in charge and the person receiving everything be the same? So can the successor trustee who will be in charge of everything and the beneficiary who will be receiving everything, can they be the same person? And the answer is yes. And it's very common that they are the same, whether it's adult children or siblings or grandchildren. It's very common practice to have the successor trustee and the beneficiaries be the same individuals. Okay, next slide. What's important about a living trust, the key is to make sure that your living trust is funded. Funding your trust means that you are transferring ownership of your assets into the trust name. If a person sets up a living trust and creates the living trust document, but they never transfer ownership of their property into the name of the trust, or they never transfer ownership of their investment account into the name of the trust, then the trust won't do its job because it doesn't own anything. The trust will protect from probate assets that it owns. And the way that you have the trust take ownership is you have to change the title on your asset, and that's called funding the trust. So if I own a house and the title on my house is Sarah Polinsky, once I set up my living trust, I then will have to change the title of my house into the trust name. So the title is going to transfer from Sarah Polinsky, an individual, to Sarah as trustee of the Sarah Polinsky Living Trust, or some language similar to that. In order for the trust to take ownership of the asset, the trust name has to be on title. So the transfer of ownership transfers to the name of the trust. But I, as the owner and creator of the trust, I am in charge of everything. I'm the trustee during my lifetime, so I can manage my property as I did before the trust. And while I'm alive, remember, I'm still the beneficiary. So if I decide to sell this house that I transferred into the trust, I can do that. If I want to buy another house and put it in the trust, I can do that. But if the trust never takes ownership of the property, then it's not going to do its job and protect it from probate. And so that's key, making sure that not only you have your trust set up, but that it's funded with the name of the trust on title. Similarly, assets that have beneficiary designation. So those exceptions to probate, for example, that we talked about, retirement accounts like 401ks or IRAs, annuities, life insurance policies. When you have a beneficiary on an account, that beneficiary will receive the proceeds from that account at the time of death. You don't put those assets into the trust because they have a beneficiary. But what you can do in some cases when it's appropriate is you can name the living trust as the beneficiary of those assets. It depends on what type of asset it is and what the client's wishes are for the distribution of the money from those accounts. But anything that has a beneficiary designation on it will not be part of a transfer to the trust. Because if you have a beneficiary, it will pay out to the beneficiary, not through the trust. Okay, so there's a distinction. So if you have a living trust, make sure it's funded, make sure the ownership is current. Many times I have clients who set up a trust when they owned one house, and then 15 years later, they had sold that house and bought another house or bought investment property, and they forgot about their trust and they didn't transfer it in. And so if something had happened to them, that other property, that newly acquired property, may have ended up in probate. You can always add property to your trust by changing the title, as long as you're alive and competent to do so. It's not set in stone that whatever you own at the time your trust is created is what the trust is funded with. During your lifetime, you will transfer assets into the trust and out of the trust as you acquire property or sell property or open accounts or close investments. You just have to stay on top of it and make sure that whatever you want to be in the trust name goes on title. Okay, so that pretty much wraps up the explanation and kind of digging into the basic documents. Hopefully there's a better familiarity with wills and trusts and powers of attorney, probate. With regards to powers of attorney, I just want to point out quickly, there are two kinds. There is one for financial decision making and one for medical decision making, and you need both. Because if someone's going to act for you in a medical capacity, they'll need a healthcare directive. And if someone's going to do banking stuff for you, you'll need a financial power of attorney. But hopefully now there's some clarity and a better understanding of how these documents serve you and how they will help you to protect yourself and empower your loved ones to take care of your affairs if need be. And I thank you for joining me, and I hope that this was helpful and informative. Thank you.
Thank you, Sarah, for that informative presentation. I think the thing that stands out the most to me in this presentation is that we caregivers need to prepare ourselves, both legally and financially, for the day when our loved one becomes incapacitated. Now, of course, it's a hard conversation to be had, but listening through this presentation today, it is evident that avoiding the conversation really won't help us in the long run either. It might even end up making things more complicated than we originally intended. So we hope that this video and this presentation has helped you to understand some of these legal and financial issues that may come up when you are caring for someone in your family. Now, thank you for joining me today as we learned about wills, trusts, and powers of attorney. And a very heartfelt thank you to Sarah Polinsky for her presentation. As I mentioned at the beginning of this video, the USC Family Caregiver Support Center is here to help educate you, connect you to resources, and support you throughout your caregiving journey. Please be sure to visit us on our website at www.fcse.usc.edu or visit our social media pages on Facebook, Twitter, and Instagram to learn more and connect with our center. If you enjoyed this video and found it helpful, please like it below. Also, make sure to click on the red subscribe button to subscribe to our YouTube channel and be notified every time we post a new educational video for the caregiving community. Take good care of yourself, and until next time, just remember that caregivers fight on.